Exam is around the corner. I kind of blank about the erring for injunction. Can you explain about it?
Okay, actually, erring fraud are one of the types of modern injunction. Injunctions are orders that made by the courts either restraining or requiring performance of a specific act in order to give effect to the legal rights of the applicant. And an injunction is an equitable remedy. As equity acts in personam, the injunction will apply as long as the defendant is in the jurisdiction. Okay, so in general, an infrared property injunction can be defined as a stay order until an appeal on the matter is heard. This injunction does not differ much from other types, except that it is granted to an applicant for interim postponement pending the hearing of an appeal. And the landmark case is the Erring Fraud Properties Limited against Cheshire Country Council.
Oh, as far as I am concerned about this topic, the injunction is a pending appeal, also known as erring fraud property type of injunction, may be made orally, grant applicant a limited injunction, and pending an appeal when the application on interlocutory injunction is dismissed as a precautionary measure, so not to render the appeal. The purpose of the order is to prevent the court appeal decision that rendered negatory, so that the court should have reserved the judge's initial decision. The landmark case, as you mentioned, erring fraud property, the Megari judge said that a judge who feel no doubt in dismiss a claim to an interlocutory injunction may perfectly consistently with his decision recognize his decision may be reversed, and that the comparative effect of granting or refusing an injunction pending an appeal are such that it would be right to preserve the status quo pending appeal. Do I know about the erring fraud?
Oh, so that is basically the nature and also definition of erring fraud.
Hi guys!
Hi.
Can I join you guys?
Sure, sure,
Okay.
Anis, have you studied about erring fraud injunction in Malaysia? Because I kind of wondering about the reception of it in here.
Oh, reception injunction in Malaysia.
Yes.
I have studied a little bit. So,
Alright.
it's for you guys. So, injunction had been applied in many Malaysian cases.
Okay.
The purpose of the order, as you guys know, is to prevent the Court of Appeal decision from being worthless should that the court reverse the judge's decisions. In other words, the judge is the pending appeal against the decision of the judge who has set aside an injunction which had earlier been granted.
Okay.
So the referred case, of course, from the landmark case, which is referred it's the properties versus Cheshire. Yeah, as you guys know. So the referred case was a landmark case which applied in the referred junction and was followed in a local case, Selcom Berhad against Inmis Competition Sdn Berhad, wherein Zulkifli Ahmad Makinuddin judge dismissed the Selcom application to prevent Inmis from filing a winding up petition against Selcom. However, the state judge had allowed Selcom application for an irrevocable injunction to restrain Inmis from taking any further steps in winding up petition to maintain the status quo pending the hearing of the appeal. Zulkifli Ahmad just said that although he had earlier dismissed the plaintiff application, it is viewed that the jurisdiction to hear the application for an erring fraud injunction and to grant the same. For this provision, I would like to refer to the case of erring fraud properties. So in erring fraud case, His Lordship Megari judge had stated most important basis for court to grant erring fraud injunction, which is the court will look whether the applicant has met a sufficient case to have responded restraint pending the trial. On the trial, the question is whether the plaintiff has sufficiently proved his case. Other than that, the court will also consider whether the judgment that had been given is one on which subsequent party are to be free to act despite the pendency of an appeal, as well as the possibility that the judgment may be reversed or varied. Besides, application for injunction was also made in Tahan Steel Corporation and Bank Islam Malaysia. The plaintiff applied for an irrevocable injunction, restraining the defendant from enforcing the security document in favour of the defendant until the hearing and final disposal of the plaintiff appeal. In the Court of Appeal, Abdul Malik Ishaq judge, in his discretion, addressed the issue of the court jurisdiction to grant erring fraud injunction. In this case, the jurisdictions to entertain an irrevocable injunction can be seen in Section 43 of the Courts of Judicature Act 1964, which states that where application may be made either in the High Court or the Court of Appeal, it should be made the first instance in the High Court. So that means that when you want to apply for an irrevocable injunction, you should make a application in the High Court first. So that's as far as I know lah. So anything that you want to ask, maybe we can discuss together.
Hey, Anis, what about we have a lunch? So we already lunch, right?
Yeah, I already had my lunch.
Alah, okay, jom. Let's go.
Bye. Thank you for the explanation. I wonder, what is the example of Malaysian cases, English cases, and also the provisions on Arifat injunction?
Hi Sue, what are you doing?
Hi, Sue.
Hello.
Hi.
What are you doing?
I'm currently studying about Arifat injunction. So I kind of wondering, what is the example of Malaysian cases, English cases, and also the provisions on this injunction?
The case that I already found that relate to the Arifat injunction is the case of Sarabanan versus Sabashini, where the parties were husband and wife who married pursuant to the civil ceremony marriage that was registered on 26 July 2001 pursuant to the Law Reform Act 1976, where both of them are Hindus, and then they married and have been given 2 children on July 2006. And then the wife receive a notice from the registrar of the Syariah High Court from Kuala Lumpur, where informed her that the husband had commenced proceeding in the court for the custody of their eldest son, where the hearing took place on 14 August 2006. In that notice, it also provided that the husband had converted himself into Islam together with his son, and then the son's conversion was carried out without her knowledge, without the wife's knowledge and consent. So the wife appealed against the order, dissolved the injunction, while the husband appealed against the grant of the Arifat injunction. So in the Court of Appeal, it was held that under Section 51 of the Law Reform Act 1976, the wife is given the right to the petition for divorce in the civil court, and the civil court has the power to make provision in the wife for the wife and for the support, for the care, and for the custody of the children. However, under Section 54B of such of the Specific Relief Act 1970, the civil court cannot issue the injunction to stay proceeding in the Sharia court. The wife has the right to apply to the Sharia Appeal Court to exercise its supervisory and revisionary power to make a ruling on the legality of the husband's application and the interim order obtained by the husband on the ground that the Sharia court had no jurisdiction over the matter, as she is not a person professed the religion of Islam. Therefore, at the end of the case, the court held that the wife's appeal was dismissed with cause, while the husband's appeal was allowed with cause.
So that is an example of the Malaysian case on Arifat injunction. What about the English case?
Really, in accordance to English law, there are 2 cases regarding Arifat injunction. The first case is Wilson against Church, which has been decided before the landmark case of Arifat. And the second case is the case of Ray Harrison's share under a settlement. This case basically provides the circumstances where a Arifat injunction may be applied, where a freezing order has been imposed ex parte, and it can be set aside in accordance to inter parte hearing. The condition is the second application should be created before the making of the judgment in accordance with the primary interim application. In this case, the Chancery Division of the High Court of Appeal received an application regarding the approval of a scheme in trust matter involving in funds and a certain person. It had been stated by the court that an order pronounced by the judge can always be withdrawn or altered or modified by him until it is drawn up, passed, and entered. In the meantime, it is provisionally effective. By regarding to the case, the court has the power to change their judgment, even though it has been announced to parties involved in the disputes, but it cannot be done when the decision has been made and has been entered or issued.
I see.
Alright.
So, how about provisions?
Okay, based on what I found, the provision which regarding to arraignment for injunction can be seen under Section 54 of Specific Relief Act 1950, which is that the condition where the injunction cannot be granted. The refusal of injunction was clearly mentioned and explained under Section 54, Clause A to until K. In application which would not fall under any circumstances stated under Section 54, the court would still reject the application in case of delay, failure to provide full and frank disclosure of material facts to the claim, and no cause of action exists, and also the other consideration that the court deemed as inequitable to allow the such application. The provision under Section 54, paragraph clause B of Specific Relief Act can be seen through the case of Sabshini and Saravanan, which stated an injunction cannot be granted to stay proceeding in a court not subordinate to that from which the injunction is sought. Okay, that's all what I understand regarding the
Okay, so as a conclusion, it can be deduced that actually in order for the court to grant in the arraignment for injunction, the applicant must first fulfill the requirements. Okay, this means that the court will look whether the applicant has made out a sufficient case to have the respondent restrained pending the trial, and court will also consider whether the judgment that was made is on which the successful party ought to be free to act despite the pendency of an appeal. Okay, so I have finally understand the concept of arraignment for injunction. Thank you guys for explaining to me.